Rape myths are prejudicial, stereotyped, or false beliefs about rape, victims, and rapists. They serve to deny, downplay, or justify sexual violence. The twin myths have been common in trials and suggest that sexually active women are less credible and are more likely to consent to sex. Sexual history evidence is an important issue at trials because the jury is often asked to make inferences as there can be a lack of expert or third-party evidence to rely on.
Section 44 of the Evidence Act requires that sexual history evidence with people other than the defendant can only be admitted if it is directly relevant, and excluding it would be contrary to the interests of justice, therefore providing for a higher evidential threshold. The purpose of this section is to avoid assumptions based on the twin myths and to reduce humiliation faced by complainants.
This section is not as effective as it should be. There is no definition of what evidence comes under the section, which leads to inconsistencies. In some cases, evidence, such as how the complainant acted with another person on the night of the alleged rape and the use of contraceptives, has been admitted without any discussion of Section 44. Sexual history evidence has been admitted under the test where it was only used to challenge the complainant's credibility. The admission of evidence like this can be linked to the twin myths because it is being used to show that sexually active women are less credible.
The admission of sexual history evidence can and should be avoided, as it is often irrelevant, embarrassing, and can lead to the re-traumatization of victims. Reform of Section 44 is required to provide for a consistent approach, and the Law Commission has identified this in the review of the Evidence Act. However, statutory reform alone is not enough. A change in social attitude towards rape and rape myths is required in order for reform to be effective.